listen to them.
Started. Oh, okay.
Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
If they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection.
And we are back, and we're back. Thank everybody for watching today. Go ahead and hit that like button. It helps you because it helps us. By the way, y'all, yes, please do hit the like button. Hit the like button. If you're in here, drop a comment, y'all. You know, don't come in here and just watch. Drop a comment so we know you're here, and do hit the like button, please. And it helps us because it helps you. It helps everybody, and it only takes a second of your time. So go ahead and do that for us, please. Now, as you know, there's not going to be any court for today and the next 5 days. So 6 days total. People are going to start, having court withdrawals. What are we going to do? So we're bringing you some content. This is going to be the mistrial series. We're going back and we're trying to find all of the in-court mistrial petitions so that we can bring them to you. The reason why is yesterday I saw somebody online, I think it was Black Law Student on X, said that there have been approximately 45 mistrial petitions. They have all been denied, of course. So let's go back and take a look at them. Let's find the ones that happened in court, see what the context was, and of course, we already know what the outcome will be. So for you to get your court fix, we're going to be bringing you the mistrial petitions every day until we get back to court next week. Now, I will tell you, the audio on some of the older videos is a little bit choppy, so try to bear with it, y'all, okay? And the audio will get better as the videos come closer to today's date. So we're starting off, the first mistrial motion was literally the first day of trial. So we're starting off from the furthest day back, and we're coming closer to today. All of these are going to be under Judge Glanville, by the way. So try to deal with the audio issues. So without further ado, this is a sit back, relax. You can just play this in the background. Nice long video to get you a nice court fix, a nice YSL trial fix. Hit the like button. Don't forget to comment, subscribe, and let's get into it.
You'll hear evidence that after the murder.
All right, y'all. So we're going to see that there's a mistrial motion literally on the very first day of trial. For some of you, this may be a bit of review, but many of you maybe didn't watch from day one. So there's literally a mistrial motion from day one. And then apparently we have another 40 something to go. So on this video, we're going to see, I think, 4 or 5 of them. And we're also going to get all of the context that goes with the mistrial motions too. So I'm not just going to play the motion itself because you won't know exactly what happened if I do it that way. So here we're going to take a look at what leads up to the motion, and then we're going to look at the outcome of the motion. You already know, because there has been no mistrial granted, you already know that the mistrial they've all been declined or denied. But we're going to get some context here as to why the mistrials were requested in the first place. So this is day one. DA Love is talking, and we will see why the mistrial motion is going to be requested as a result of what DA Love says here.
Of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift Young's Limelight had with other people in the community. So what are they accused of, and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those. The crimes that the state will be proving to you over the next several weeks include conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO. There's no substantive allegation of RICO violations here. And by that I mean there's a difference. Here the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement, to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if two people said, okay, you know what, we're gonna go toilet paper our dean of admissions house. And they sat there thinking and talking about it, and someone overheard them and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all are in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they're agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which that they are agreeing to participate in this organization, this enterprise, through racketeering activity. You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which that they are agreeing to participate in this organization, this enterprise, through racketeering activity. You'll see evidence, as I stated, of not just drug sales, trap
I
houses,
can't believe I
drug
was on.
houses.
I'm over here on mute this whole time. All right, I'm gonna have to go back and say it again. Oh, y'all didn't even get what I was saying. Okay, I played that several times. I'm on mute. I'm ranting. I'm on a rant. All right, chalk it up to new streamer. Okay, I'm on a rant. I said here, she says trap houses. She says drug houses, and I know y'all couldn't hear me, but now you can. Trap houses, drug houses. Does she say hoe houses or does she say whole houses, as in entire houses? So I was on my rant twice. You didn't hear me, but now you can hear me. Maybe y'all figured that out anyway. So I'm gonna play it one more time. Is it trap houses, drug houses, hoe houses, or is it trap houses, drug houses, whole houses? All right, now y'all heard me. Now y'all heard me. So listen up. Let's rewind it back and see what she said.
This enterprise through racketeering activity. You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which.
Yeah, that was whole houses, wasn't it? Wow. Miss Love dropped some weird, I mean, as in the professional, the professional world, Miss Love, she'll drop a bomb on you every once in a while. Hoe houses. She literally said hoe houses. That's what I got from it. So y'all, some people picked it up anyway. I guess y'all heard that even though I was on mute. Shout out to Cat and I Williams, one of my favorite streamers. Of course, I was in Cat's live every single day until I started dipping my toe into it myself. So I know I was muted, y'all. Sorry about that. I will try not to make that mistake again. So y'all, have we seen any evidence of YSL having hoe houses? Have we seen any evidence of YSL having hoe houses? And I'm just using the term she used, okay? I literally have never said that in my life before today, and I'll probably never say it again unless I'm referring to this, okay? So don't hit me with that. Don't hit me with that, okay? We got to hit DA Love with that. So have we seen any evidence that YSL has had hoe houses? You know what I'm saying, y'all? Anyway, I'm going to let it keep playing. I did not play this clip for that reason, but I did pick up on that when I was editing this out. And I was like, did she just say hoe houses? Anyway, I'm going to let it keep going. We're leading up to the first mistrial motion, which is coming up soon.
Sales were conducted where they held long-arm guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Fomarius Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick, and their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
You have an objection?
Yes, sir.
Basis.
Motion.
Okay, y'all. So this is literally the first mistrial motion of the actual trial. Okay. I didn't go back to like the pretrial hearings and whatnot. I don't even think you could likely do a mistrial before the trial starts. So I'm going to rewind it just a bit. Okay. And as the infamous, the illustrious Cat, not Williams, would say, sorry for being a pausey McPausertons. I'm giving you your credit for that, Cat. But I just want us to try to figure out what led up to this, because I personally didn't hear anything that sounded like it should have been a mistrial motion right there. So I'm going to play it back about 30 seconds. We're going to listen.
Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick, and their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
You have an objection?
Yes, sir.
Basis.
A motion.
Did anybody catch it? I didn't catch it. Morning, Empress.
Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters jury deliberation room, and we'll call you back in just a minute, okay? When we finish up our business, all right?
You're right.
Remember the court's admonitions, ladies and gentlemen.
You're right, Kat. It wasn't something she said. It wasn't what she said. It was what they were showing on the screen. That's like that. I just edited this morning. I should have remembered that, but I was doing a lot.
All right, please be seated. Our jury has left us.
Appreciate it.
All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up, and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder, and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to this honorable court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it.
Kat, let me borrow your term, Pawsy McPausertons. I think is a great term. So I'm gonna be saying it. Everybody who's here, I got it from Kat. Y'all, so everything we've been seeing started on day 1, y'all. I mean, everybody here, maybe you all mostly know this, maybe you don't. But honestly, I wasn't watching this trial from day one. So, this to me, and even if I had been, this is just underscoring that, like I've been saying, that DA Love is like a Dennis Rodman, a Draymond Green, a Ron Artest type of player. I hate to use the term because, and Kat, thank you so much for gifting. Wow, excellent. I appreciate it. I hate to use the term dirty because I really try to be respectful to the players, the people in this, but it's like Judge Whitaker said, either it's dirty or you are just so bad at this that it looks dirty. Either it is dirty or you are just so overwhelmed with work. You're just not organized. You don't know what you're doing. Some kind of way it is. So we see this on day 1. And it's just going to continue throughout the trial. So sorry for pausing, Kat. I want to. Oh, Kat gave herself a membership. So thank you. All right, y'all. Thank you. I'm going to let it keep going.
Is next court exhibit in order of the state's presentation anyway. So, all right. So that'll be court 1 for purposes of the trial. So, Miss Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to
the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
Excuse me. I was never said this, ever. That's it.
So what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before the Honorable Court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
Brought him up to this Honorable Court, outside the presence of everybody. We're an open statement. I am lied to. I am saying that. I am lied to. Or if anyone else got that exhibit, I did not get that exhibit. And I'm seeing everyone say shaking no. And now it goes against the court's word. We are bound, duty bound to follow some of the court's order.
Going to join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting
Y'all know one thing though. If you listen, pay attention to Glanville. Glanville always sounds half uncertain about himself to me. When comparing Glanville to Paige Whitaker, to me, Glanville sounds like he gets to about 80% certainty, where Judge Whitaker seems like her minimum is about an 80% and she'll go from 80 to 100. Glanville seems like he's always like at 80% certain and less, where Whitaker seems like she's at 80% and more. Glanville just always kind of, oh yeah, that's right. Like, people are correcting him and stuff. I don't know. It's just Glanville never seems like he has that legal background where he can say this is the way it is. Where Whitaker seems like she's just, no, this is how it is. This is the way it works. So
that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that. I ruled upon that last week. I did. That we were not, I would take it as it came in this case. And if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
and Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have
all right.
the slide.
Well,
I have it now. I'm
court
about to share
court
this.
one for purposes of the motion for mistrial.
all right, y'all. I know I keep pausing. Sorry. I want to give I didn't get to do this in the video we're watching, so I want to give Black Law Student. I believe this is a man, so I want to give him his credit. This is what gave me the idea for this series. This is from yesterday. He said, and someone just asked, what's the mistrial count? I'm not keeping count. But he said, breaking news, Young Thug RICO case has set a real world record this morning, not for being the longest trial in history, but for another unprecedented reason. The YSL defense lawyers have officially filed 45 motions for mistrial in a criminal case, none of which have been granted. This has never happened before, or this has never happened in U.S. history. So I cannot verify that. It did get me thinking, what am I going to do during these days off? So I want to give Black Law Student credit. I did mention this in the video, but I couldn't find this tweet for some reason, but here we have it. So the answer is apparently 45 motions. Now, all of those I do not believe were filed in court. So I don't think we're going to be able to see all 45 of those. Some of them were probably written motions for mistrial. But we'll find the ones we can find that we can find video of. So this must be the slide that's in dispute here. So this is the slide that's in dispute.
All right.
Well,
Yeah, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what was it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So,
Your Honor, I'm supposed to ask for a reoccurrence report for my mistrial before the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
you've made your motion for mistrial, and the basis, and I'm going to mark the whole state's presentation as court one for the purpose of your motion, and it will go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today.
All right, Ms. Love.
Yeah.
Wait.
Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion, but to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation. And just like this, so I assume that what you told our jurors is what you expect the evidence to show. Yes.
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on here.
I got that, but he's talking about, is there anything else you're going to use in opening you haven't shown to defense counsel? He's telling us. Well, I said that. I told you to do that a week ago.
Your Honor,
Because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
Can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, Ingram, can you find out if our jurors are ready?
Are they with them?
Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, we have a few. Your Honor, Jay Apt on behalf of Mr. Kendrick, can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Who's talking?
Max Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell. We've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial. And if Your Honor.
I'll apply the Harvey rule unless you tell me otherwise. Okay?
And that will apply throughout trial.
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be in recess about 10 minutes. All right?
Your Honor, what I'm going to do before sitting is I'm going to actually do a search for the first 4 letters of Mr. Steele's name and make sure that I didn't leave anything else in there. So before I do that, I'm going to send that.
46, 45 or 46. Mistrial request. $45 or 45.
If I may, Your Honor.
Yes, ma'am.
Regarding the court's earlier concern brought to the court's attention by Mr. Williams, Ms. Hilton shared with me what was said on the bench. But as it relates to Cordelius Ryan's post after the murder of Shamel Drinks, that was provided from day one in discovery, Your Honor. And it is not a crime that he is alleged to have committed. We may have put that on a list, including things, but Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act. And it is what the evidence is going to show happened. What I have in the PowerPoint, I can show to the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the date that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury, that the evidence will show is just that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are the things that the courts have said jurors and the courts should look to in determining whether something is done in furtherance of a gang. And so I would ask the court, I didn't take it out as the court instructed. I would ask that the court allow me to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. Adams. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose, is what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed as the court. You all could, we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes. And I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as.
Say again, madam, I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to.
Yes, ma'am, I would probably agree with you, but
So they
did
should
I
have it there.
ever rule on that issue?
You said that you would do it later as it came
Okay,
up.
well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks. And my client has nothing to do with that.
That was another area I'm correct. Thank you.
But
All
they
right.
didn't get that
Ms.
slide
Love says
presentation
Ms.
earlier.
Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So Ms.
What's your
Love
objection specifically, sir?
attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share it with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I said to them, if they can, actually, I sent them to them. So there are some, I have only about.
Your Honor, they're done over.
Hold on, wait, let her finish, and then I'll let you respond, Mr. App.
So all of these slides that involve Christian Eppinger, I sent to them. And other than the slides involving Christian Eppinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards of showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that, I'm not certain if Mr. App thinks that we only served 4. Maybe, I don't know if he had trouble opening it up, but we served, I think all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I will share it if I did not with the court as well. But these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barber shop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted. And then I have pictures of Christian Eppinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my work product on them.
All right, Mr. App, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument. But if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. If there's no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of our opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time.
Y'all, StreamYard had an issue. Sorry about that. Let me put the screen back. I don't know what happened. Lift off on me. Sorry about that.
Slide 15, the third bullet point, it references October 1st, 2020, in terms of that quote from the text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. That's number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquavius Huey. And then when you go to slide 16, slide 16 is an overt act that is alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020. But in the indictment, that particular overt act is November 16, 2020. So that's a third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury, Judge. So I would ask that the state correct that, remove it, or correct it.
All right, anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang, even after being indicted on these charges. We have we began to discuss intrinsic acts and other unindicted allegations last week, but we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet. And I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also I'm looking at it now, 48, 49, 53, 54, 55. That's your prerogative, that's within your zone, that's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
In terms of what slides are you talking about? Mr. Steele again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding, so it's 48, 49, but then skipping to 53, 54, and 55.
48 and 49. Your Honor, may I share via Zoom the slides that Mr. Steele?
I would, yes, please.
Thank you.
Y'all, we going until we get
And
some
we
Glanville
said
decision.
45.
So till he
Just
says,
share the presentation, please.
Yes, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid, some of them are embarrassed, some of them are intimidated, some of them don't remember, some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is, as the court has already instructed, which is just to use your common sense because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are there. So I can take out.
So that's different. You might want to just redo it.
I can do that.
so they're making it up as they go.
Any further objections, folks?
Yes, Your Honor, I went over to the state's table, Carson Matthews and Beth Mr. went over to the state's table and brought to their attention an error at slide 42, and I think it's incorrect.
All right.
Is that correct, Nate?
Here's
Not yet, but in a moment.
All right, here's what I'm going to do. Folks, this is exactly why I told you I wanted you to, and let me go ahead and just say this. Ms. Love, I told you to give me your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone, and the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reasons I told you all to do that. So,
Your Honor, as far as any typographical errors.
I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Shard have made are errors, and Ms. D. Williams need to be corrected. Okay?
Yes, Your Honor, I will, of course, do it for the record.
But everyone else needs to see it so they can be comfortable and make sure that you represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. Will do. And Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence. And if I misspeak or miswrite,
But that's not the point. I'm going to tell them that. But and I told them that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay? So, all right. Desiree, Sergeant Ingram, can we go ahead and call for our jurors, please?
Your Honor, officer number 6-2.
You can go ahead and take up that during the recess. Okay?
Yes, sir. Thank you.
All right.
Good.
Yes.
All right, y'all. So that was all of that. And
I'll let you leave in 45 and 46 over objection.
This is after the break.
47, judges rule, 47 needs to come out.
So the one about with the finger pointing that,
Finger in the eyes are fine.
okay. And I took out judge's rules
I got 47.
and I think I've already taken out 47.
47 is judges rules again.
I took that out.
Any further objections, Mr. Steele? Because I am going to leave in 45 and 46, okay? But I'll take out the other ones that you just mentioned.
Okay.
So waiving my mistrial, thank you, sir.
Say again?
I apologize. Without waiving my mistrial, thank you, sir.
Your motion for mistrial has been denied, and I've noted your objection for the record, sir.
And confirming everyone has 1 through 52 with the edits that the court has directed.
okay, so that was the first full. I tried to give as much as possible because you see the motion wasn't denied until much, much later. But y'all saw everything we're seeing today. Literally, this could, if you replace Whitaker with Glanville with Whitaker, this could have been yesterday, right or wrong. I mean, it's the exact same stuff, exactly the same. So when Whitaker came on, she's like, well, I'm not looking backward. That really did a huge disservice to the defense because you looking backward, you would see, oh, this isn't something that's happened. This is a method. This is a personality trait, meaning of love. This is a modus operandi. I think I said that right. So that's the first mistrial motion. This second one, y'all, I don't really know what led up to it. I didn't see it in the trial. It was just mentioned at the end. If anybody has some context, you can help provide it.
Yes, it is.
Okay. I'll have to go to the second.
Ms. Love, prior to earlier, about an hour ago or thereabouts,
This is another
you were
day.
about to mention something about.
By the way, y'all, you'll notice this. This is not the same day. You can probably tell. So this is, I'm going to have to go back and try to find all the dates and put them in the description. I should have noted that down, but it's another day.
Checking on the record as it pertains to Mr. Stillwell. I know that there's a motion that was made, and I've already ruled on that in terms of mistrial. So do you have anything else you wanted to add at this point in time?
I did, Your Honor. Just for the record, we had already introduced as Exhibit 77C, I believe, 77 Indigo. India. The certified conviction for Mr. Nichols previously.
Okay. I will still note Mr. Shorts and Mr. Harvey's, I should say, objection for the record. Okay.
It was a motion. I think it was on the record.
Yeah, it was here at the bench. It was a properly recorded bench conference. You moved for mistrial on the basis of the witness testifying about prison.
Certified copy of the conviction doesn't go out.
And I said, I'll take up all that stuff later. Yeah, I mean, but it's been testified to or presented on the record already. Okay, sir. All right. Does anybody have any other ministerial inquiry of me at this point in time?
Not from the state.
I was just kind of being kind, Mr. Yes, Mr. Matthews, what would you like to present?
Just want to clarify, never a motion for mistrial if that happens to get moved by a particular defendant. There will be the court's instruction to the rest of us that we should leave those independent motions.
Well, it depends upon the circumstances of the mistrial. Like, that doesn't have anything to do with you and your client, okay? So that's why I'm saying that I don't think it would be proper at that point in time for you unless you have an independent basis. So that's why I'm saying if it's something that affects all of you, I will note it, and you won't have to do that. But since that particular motion was specific to Mr. Stillwell, or Mr. Nichols, I should say, then that's why I made the motion. But the Harvey rule is still in effect, okay? All right.
All right, so that was
Anyone
all
else?
for that one. That was all for that
All
one.
right. Unless you have anything else about scheduling I need to take up with you at this point in time? Are we set for?
Now, in your experience as an investigator, do all investigators investigate cases?
Now we
the
have
same way?
better audio. Thank you.
Oh, no. It's just like any other walk of life. I mean, everyone has their own style. And usually your style comes from how you carry yourself in the street and your experience out there with the citizens.
Y'all, this witness is so funny to me, y'all. Just his style of talk, you know.
In this case, the citizens of Fulton County, City of Atlanta.
Tell us a little bit about your investigative style.
Everybody calls me old school.
How old will the objection, Mr. Steele?
I am Atlanta. And
Oh my gosh.
I feel like every case I work is a story.
Yeah.
And I've got to report back, the information from that story. I always say when I work my investigations, I want to have on a belt and suspenders. I want to make sure I got everything. And sometimes, commanders and supervisors don't like that. I mean, I take my time slow and methodical with how I work my cases. I don't move very fast.
Cases. I overrule the objection, Mr. Short.
Thank you.
You could say.
That's pretty much it. I just try to keep, you don't get all the answers when you're working investigations like they do on TV. But what you do is you try to get as much as you can, and you miss things. I miss things on every investigation. And so you have to take your time to make sure you have it right.
When you're conducting an investigation, generally, what type of evidence are you looking for, say for your homicide cases? What type of evidence do you want, are you trying to gather as a part of your investigation?
I mean, first and foremost, I want eyewitnesses. I want humans to give information that could lead to some kind of inroads in closing this case. As I got older in the department, technology became a useful tool. We've always had fingerprints. You want fingerprints. DNA became a really big deal around 2002. I've watched everything change, but I always, with any kind of testimony that I receive from a witness, I want to get something to back it up, something tangible that'll vouch for this person that's an eyewitness seeing something. But I really like eyewitness evidence. A lot of people don't, but I do, because the community, that is the witness.
Now, in your time as a homicide detective, have you had the occasion to interview suspects?
Absolutely.
And tell the jury a little bit about your interview style.
I try to keep my interviews.
Overruled, Mr. Sharp. Have a seat.
I try to have conversations. I mean, from these conversations, I try to have them make sense. You know, I don't want it to be overbearing. Sometimes those conversations, those interviews can get heated, but you want to build some kind of rapport with the person, whether it be a witness or a suspect, and make sure you're getting good information.
Do you have an objection, Mr. Steele? What's the basis?
All right, y'all. In the interest of everybody being caught up, I'm gonna play that little bit again, because just pay close attention to what the witness is gonna say, because this is what's leading to the objection. Again, I missed it the first time, so I'm gonna play this again. So listen closely.
From these conversations, I try to have them make sense. You know, I don't want it to be overbearing. Sometimes those conversations, those interviews can get heated, but you want to build some kind of rapport with the person, whether it be a witness or a suspect, and make sure you're getting good information.
Do you have an objection, Mr. Steele?
That was it.
What's the basis? All right, come on up.
May I proceed, Your Honor?
Yes, you.
Let me ask you this, Detective Quinn. Over the course of your 30 years, how many people have you interviewed? Just roughly.
I mean, thousands. I mean, I can't put a number on that.
Okay. And you talked a few moments ago about building rapport. Tell the jury, why is it important to build rapport?
You don't want your interview to be adversarial. You want people to be calm and give you truthful testimony that you can verify later.
Mr. Steele, you got to pose an objection, and then you got to tell me a basis, because selling your honor doesn't let Ms. Weaver know who you are. So please go ahead and objection and tell me your basis.
I have a motion. I have a motion.
All right, ladies and gentlemen of the jury, can I get you to step into your headquarters for just a second? Detective, can I get you to step outside for a minute? All right, ladies and gentlemen, our jury has left us and our witness is off the stand. Yes, Mr. Steele, what's your motion?
Y'all, we're gonna have two motions from this trial on this day, by the way.
Your Honor, I tried to preempt it at the bench. It's exactly what I asked. And I'll wait for Ms. Weaver if the court needs it for the exact quote. But Detective Quinn just said, upon questioning the district attorney, why is it important to develop a rapport with a witness? And the answer was something to the effect of, to get truthful information. No witness can talk about veracity or truthfulness or believability of anybody of anybody. That's what I tried to say at the bench. That's the entirety of this testimony so far. I'm moving for a mistrial on Mr. Williams because this gentleman interviewed a big witness in this event, the only witness that puts Mr. Williams involved in this event. And now it's important to get truthful information. I don't know how you wipe that out. You're going to tell the jurors, ignore that last comment? That's what you're going to say? And I warned it. And I was at the bench and you did not want to hear from me more than you did. You told me to step back, but Your Honor, I've been doing this too. I anticipated it wasn't that hard to do. I'm moving for a mistrial and I did it at the proper moment. All right, Ms. Hilton?
All right, y'all. That's the first of 2 motions for mistrial that Steele is going to make today. Okay, meaning in this court day.
Your Honor,
Have a seat, Mr. Sharp. Let her finish, okay? All right. Remember, the Harvey rule is still in effect, so have a seat.
Your Honor, as it relates to Detective Quinn's response, he did not talk about a specific witness, truthfulness, or veracity. He said, in general, what I'm trying to do is to find the truth. And that is what you do in an interview. You're determining whether or not what the person who's speaking to you is credible, if they're providing credible information. Your Honor, even in this case, when you listen to the interview that has already been admitted, Detective Quinn already tells Agent Bain, I don't think you're being fully honest. So he's not talking about the veracity of any one witness. He hasn't even talked about any witnesses yet. So for defense counsel to deem or ask for a mistrial at this juncture, given this testimony, we're going to ask for you to deny.
All right. I'm going to deny the motion. Summon our jurors, please.
For the next questions asked, I have to review my motion.
Oh, y'all
It's
see?
noted.
Oh, let's just get that face.
Yes, and I preserved it.
That face
For defense counsel to deem or ask for a mistrial at this juncture, given this testimony, we're going to ask for you to deny.
All right. I'm going to deny the motion. Summon our jurors, please.
For the next questions asked, I have to review my motion.
It's noted. I'll make it. Yes, and I preserved it. It'll be continuing. Mr. Shard, if you ask me that one more time, okay? No, I did. Listen. Everybody gets the same objection, okay? Unless there's something else.
If you could turn your microphone, if you want to take it down, you have to do it.
Your Honor, previously you informed all defense counsel that motions for mistrial were not subject to the Harvey rule.
No, I
That's
didn't.
why I'm doing this.
No, I
If you
didn't.
tell me that motions for mistrial are now subject to the Harvey rule, and that's on the record.
I don't recall my saying that they were not. So
Respectfully, I recall that, but I will just rely on the Harvey rule from now on, if that's clear for the
I'll
record.
assume it for everybody then, unless you opt out.
Thank you, Your Honor.
This is another situation.
y'all.
So that was the first one. That was the first motion for mistrial. This is going to be later on in the same day. And you're going to hear my voice because I'm playing the video that I made for you to just watch this. So that happened in the same day as the previous situation that we just watched.
I did identify 2 of the 3 that are the newer calls that have not been admitted. I identify one and I'll call.
No, sorry to pause, but this is a totally different situation. So that motion for mistrial we just saw was open, closed, it's denied. We're going to watch. This is much later in the day, hours and hours later. It's not the same motion. It's not the same situation.
Call it for the purposes of this, the chicken call, because it stands out because she's talking about cooking fried chicken. The second call after that is a call where she's at the baseball game, and that's very identifiable. It is the third call that I advised that I will ask the court if we can take a brief break so I can just identify which call that is so that they can know. But I've identified that 2 of the 3 calls.
Do you have any objections to the baseball or chicken call? I know it's not just call. You have your video yet?
Hey, y'all, in case you didn't hear, Glanville asked Steele, do you have any objections? Steele says I have to review my notes. And Glanville says, you haven't reviewed those yet? I think he's talking about the calls, not the notes. So
Okay, well, why do I need more time?
why do you need more time?
Okay, either you said to let you know if an issue comes up.
Okay, but do you have any specific objections to those 2 calls? Not the third one. We're going to need to take a break on.
As I told you. I may have, I may not, but you're going to, you told me to let you know. So I told you.
All right,
following your direction.
Mr. Steele, please don't try to engage in conversation. You're not prepared. Because if you prepared,
Are
you
y'all
told me.
This is the infamous Mr. Steele, you're not prepared. Steele has brought this up probably 10 different times. So listen one more time. You're not prepared.
Okay, but do you have any specific objections to those two calls? Not the third one. And we're gonna need to take a break on it. As I told you.
I may have, I may not, but you're going to, you told me to let you know, so I will do.
All right,
Following your direction.
Mr. Steele, please don't try to engage in conversation. You're not prepared. Because if you prepared, you'd have told me. You invited this conversation. I did. I asked you if you were ready. If you were ready, you say, yes, Judge, I'm ready. I have to do those two calls. Now, if you're not ready, then go ahead and just tell me you're not ready, and we'll go ahead. I'll go ahead and we'll figure out something else to do. But if you have any other basis, then tell me.
Your Honor, you instructed me. I raised this already. You know exactly what I'm talking about.
No, I actually
Well,
don't.
then we need to ask the jurors, likely leading psychoaggression.
How long is this third one?
So y'all, the jury was in there watching this whole thing.
Right, and I will say for the third call, Your Honor, really as it relates to this particular incident, there's only two relevant areas from 00 to 1 minute, and then 3 minutes and 50 seconds to 6:40 are the only relevant parts, I believe, for this particular matter.
Are you gonna want all of the third call to be played?
Maybe, I don't know.
I tell you what, how long is the third call?
So all the calls, Mr. Steele is correct. All the calls are approximately 15 minutes.
Yeah, y'all, that rant, that Mr. Steele, you're not prepared and all that stuff was in front of the jury. That was in front of the jury, y'all.
And the state does intend to play all 5 calls.
Your time, as much time as you want. I'm sure to refresh your memory.
No, I'm talking about the third, I'm talking about the third call.
But I need the court instructed me, I don't know why we're doing this, the court instructed me to help the court. That's what I'm doing. When it comes up, that's what you instructed me. So I'm following what you asked me to do. Now you're acting like I'm not prepared. I'm very.
All right, tell you what, will 20 minutes be sufficient for you to review your drawings? All right, ladies and gentlemen, we're gonna take 20 minutes and after that, we'll come back and
Y'all see how embarrassing that would be? The jury's there and the judge basically yells on you like you're a little kid, call you not prepared. And the jury is watching that. That's why Steele has come back and mentioned this so many times. So the jury was there for this whole thing that just happened. They're sitting there watching it. By the way, if you haven't hit the like, please hit the like button for us. Please hit the like. If you are not a subscriber, please subscribe. The plan is to bring more mistrial motions tomorrow.
Yes,
sir.
Hey, Your Honor,
Do I need to listen to the call?
you don't, but during this break, when we come back, we'll just want to know a decision about the transcript, because we do have a transcript for the first call. And that was the one we gave to him yesterday. So just a decision
Well, I
about,
thought you were gonna take more time for that because,
they have not looked at it. Okay, never mind. Thank you, Your Honor.
all right, okay. We're in recess about 20 minutes.
I have a motion. I have a motion.
In regards to what, sir?
Your comments. I have a motion.
Okay, what's your motion?
Steele is ready to go to war. You can see it.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl weeks before. There was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay.
I have, no. I need to make a record. Your Honor,
Mr. Steele, wait a second. When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection.
Y'all got to play that again. I'm sorry. That might be one of my favorite lines of this whole trial, y'all. You either have an objection or you don't have an objection. I'm sorry. Don't be upset with me, y'all. That was just great. That was great.
To whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out our presentation in front of the jury. That's for your benefit.
Whoa.
Not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong.
Okay.
What happened was, let me finish, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect.
Okay, which call? Which call?
These calls, as you.
Okay, well then why aren't we taking them up beforehand?
The state just said just now, these are the 3 additional calls that they want to introduce.
All right. Well, then here's your response. I'm going to give you an acceptable response.
Well, I'm going to make my motion. Huh? I need to make my motion.
Judge, there's more to this than we need to listen to these calls.
Right.
Then I would have no, you didn't say that though. So I wouldn't have had that opportunity. But that's why I keep telling you this. Okay. I mean, like I told you, forewarned judge, a happy judge. All right. So had you just told me up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know. I don't know what the third one they're trying to do.
Okay, well,
let me just finish. So you presuppose I don't know what the calls are. Well, I don't know what the third call is because Ms. Hilton, who's professional, said, I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at the chicken, they're discussing chicken wings. Or chicken. I understand those calls. There's issues in those calls that you need to address. But I politely make an objection and say, Your Honor, based upon what you told me, which is what you told me, we'll take it up later. I wanted to raise it. You tell in front of the jury how unprepared I am. And let me tell you something. I am not unprepared. I don't appreciate the court telling me that. And you don't, and I asked you, tell the jurors that you were wrong when you admonished me last time. You said you wouldn't do that. This is the second time. And you know what it does to me? I don't care.
I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay?
Forget about
You are a grown professional advocate. I am a grown professional jurist. And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No,
but
that man's life is here.
And
Realize it affects him.
you're doing a fine job in representing him.
Well,
but you know what? That's just the way we are right now. But the crux of the issue is, Mr. Steele, and the representatives from the state and everybody else. What happens right now is I have to take a break in order to vet all of these issues, which I'm required to do, Mr. Steele. And that's what is kind of disappointing to me, because I have given you all this administrative time, all these breaks to go ahead and do this. And this is what delays the presentation of this case in front of the jury.
You know, if I would have done what the state did, and I'm not poking anything at Ms. Hilton, you would have said to me, why didn't you share those calls with him before? What, you were out all day today. We didn't start court till 1 o'clock. I would have shared them.
I know you would have.
But the state didn't. I'm not poking fun because I can deal with it. But when the court then steps in.
But here's the problem. I have a problem with it, because at the end of the day, I got to listen to a 15-minute call.
You don't have to listen to anything.
But
you have to make a ruling.
Yes,
on
but I have to listen to it in order to make the ruling on those. And even if you said you've listened to the chicken call and the baseball call, and if you say there's other issues that come into play, it's better for us to take those things up before I ask for that jury. And I could have done that this morning. I could have done that at another point in time. So, I mean,
I raised this issue to you, and I don't remember the date, but it was days ago. I raised it, and the court said, all right, understood. And we'll take that issue up when it comes.
Okay.
What am I supposed to do? Okay. Sit there and say no objection?
No.
Exactly right.
I
said, Judge, it's an issue we need to take up.
Not at all.
And in addition to that, today alone, and this happens, today alone, the state introduced 2 exhibits. I've never been given them before, ever. You know what I did? No problem. No problem. Because I think that's professional. One was a Google map. It needs to be clarified for the record that it was not done on September 11, 2013. And then a map with little dots with 0.4 miles. I've never seen before. But I didn't do anything, Your Honor. I want to move the case. But when the court, it gives me no pleasure in saying this. I believe that this honorable court is biased against Mr. Williams and or his counsel. And I ask you to consider recusing yourself, or don't do this again to me. This is inappropriate to me. I respect you, but what am I supposed to do? Sit there while you do this? I didn't do anything wrong. I did exactly what you teach me to do and the courts teach me to do.
All right.
But instead, no, I got to finish this. Then I get told to this court says by Prosecutor Love that I'm not being candid with the court and I'm misrepresenting because Mr. Bean never went to the hospital at Grady on September 11, 2013, and Miss Love has a document on the desk to prove it. I sat right in front of Your Honor at the table, at the bench, and I said, I'd be careful what you say. That's not accurate. Miss Love looked down on me and she said, it is accurate. You said, we'll take a break, figure it out. After the break, you didn't even bat an eye. Ms. Love said, yeah, I was totally wrong. Mr. Steele's right. He was taken to Grady. If I would have done that and called another member of the bar disingenuous, not truthful, no candor, and misrepresenting, you would have had me yelling in front of a jury. You did nothing. You didn't even ask Ms. Love to apologize. I don't want her apology. I don't care about Ms. Love. But I care about the court. And now if you can walk in someone else's shoes just for a minute and see what
rewind
you're
that
doing,
real quick, y'all. Sorry.
no candor and misrepresenting, you would have had me
Watch Miss Love
yelling in front of a jury. You did nothing. You didn't even ask Miss Love to apologize. I don't want her apology. I don't care about Ms. Love, but I care about the court. And now if you can walk in someone else's shoes just for a minute and see what you're doing to Mr. Williams, because it's hurtful. I'm not the one wasting time. I'm here every day ready to go. I am not wasting the time.
I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it. And it has to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing. And then you won't apologize. And I did nothing wrong ever on
Mr.
these
Steele,
occasions or others.
I'm going to go ahead and address your motion at this point in time. I'm going to deny your motion at this point in time. And also just direct you that I had the responsibility to control the proceedings in this particular circumstance. Sometimes things get kind of heated, and that's the crucible and trial of any particular case. I am not in any way intimating or insinuating that you are not professional, you are not prepared, but the things that I am bringing up to both of you, and I have fussed at both sides for this particular issue of not being prepared in the sense of, and the only reason it affects the trial of the case is it makes the proceedings a lot longer than they should be, because all these things could be taken up. And sometimes if we've got to parse out all these things, as you can see right now, it takes time, and that's what I'm kind of concerned about, having been a jurist for a long time. So I understand that you're a zealous advocate. You in no way offend me by raising any type of motion. I think you're doing I think that you and the others here are representing your clients well, but sir, I have to be able to control these proceedings. And you at times in these proceedings have not listened to what the courts told you, and I certainly could have explored other options. I didn't. So I'll tell you that much for what it's worth.
You allowed a member of the bar yesterday ask a witness who constantly is committing, respectfully, potentially perjury. Did Mr. Steele shut off and turn on the recording? I never did that. I wouldn't do that, and I didn't do that.
Okay, and but sir,
I would have said that question about another member of the bar, prosecution. You would have come over the bench and said, "How dare you?" I sat there and I said, "Outrageous." You denied the motion. I think 3 other people made motions to strike or to object. You denied it. Judge, I'm just telling you, the appearance, if not the reality, is not good here. I'm being—
What, to who?
To Mr. Williams.
Okay, but
maybe to the others. Maybe
you're his advocate, okay? And that separate issue of whether or not you did what you did, the state accused you of that. They have the right to at least inquire about whether or not that happened. Now, whether or not it happened or not, I'm not making any comment on it, but it goes to bias, it goes to motives to misrepresent.
But that never happened.
Okay, but I'm not commenting on that. That's for the jury. That's for the jury to decide.
I asked a question about a missing recording that wasn't given of a statement made by Mr. Bean. And you told me.
And I keep telling you.
Know what you told me? You said, does the state have it? They said no. You said nothing I can do. I tried to cross on it. You sustained an objection.
Because it doesn't exist at this point in time. Now, if it exists at some point, I told you I'd say it. 1, I tell you, I apologize to you. And then 2, I'll take corrective action against the party or the entity that failed to give you that particular statement.
But the point is, everyone knows he spoke to the detective beforehand.
No, we don't. That's the whole thing. You believe it. You honestly believe it, and that's true.
On September 17th.
Sorry, y'all see why this judge was never going to be able to take this thing to trial to jury verdict. It wasn't
2013. I'm recording. Mr. Bean tells that to Detective Quinn. How is that far-fetched? Why would he ever say that? I lied to the other detective. Why would he ever say that? I mean, logic has to come into this courtroom at times. But you stop me from doing it, but you allow another lawyer make up that I'm stopping and starting a recording. And he says, well, I don't recall. I don't remember anything.
Here's the thing. That's why probably Miss Love asked me to put it under seal for the time being. But I mean, I'm not saying anything, but if true, that's a pretty serious accusation.
If true, I'll die right now. How about that, Judge Glanville?
Your Honor, I object to this.
Y'all, let me pause real quick. Let me give a shout out. Thank you, Amber Dawn, for the super chats. Amber, Steele has brought this up to Whitaker. Whitaker has either reviewed the part she's interested in, or she said she's not interested in reviewing the rest. So, Amber, I thank you for 3 super chats. I really thank you. Everybody else, feel free to super chat. So we're going to get right back, but I did want to address this. Everybody, Steele has brought this up to Judge Whitaker. Whitaker, at first, she said she was not. Steele brought this up in particular, where Glanville called him unprepared. At first, Whitaker said, look, that's for the jury to decide if you're unprepared or not. I don't need to give them any kind of corrective statement. But then later on, she said, she came back and she said, you know what? I will give them a corrective statement. They worked out the verbiage in court, and then she did give that corrective statement to the jury. So that, I think, is the most that Whitaker is going or would do as it relates to this. Anything else, Whitaker has said she doesn't care. So all of this that happened, everything we're looking at, Whitaker basically came on to the scene and said, I don't care. Not that I don't care, but I'm not going to do anything about most of this stuff. So it is what it is.
I don't care about her objection. I'm speaking with the
Your Honor,
court.
I object.
I'm
I'd like to
speaking
level
with
an
the court.
objection.
Okay.
I'm speaking
Let him
with the
finish,
court.
and then you can state your.
My point is, if you don't see what's going on, it's because you're not viewing it out of the lens
But
of
Mr.
a
Steele,
juror.
Mr. Steele, I can't do that. I have to be the referee. So the jury decides those particular issues of believability and credibility. Now, I'm not getting into the throes of war between you and the state. That's your business, and that
I
is
have
certainly
nothing to do with a throw war.
no. But I mean, it's your ability as an advocate. I told you before. That's your ability as an advocate. All right.
What I'm saying is, you said in front of this jury, I was unprofessional. I am not unprofessional. You were wrong.
I think at that particular point in time, given the totality of what happened, that's what the court's assessment was. Sir, I am.
But it was wrong.
It's a snippet in time. Mr. Steele, you're a very good attorney, but I'm a professional jurist, and you may not like some of the rulings that I make, and you may not like the way that the trial is going at a particular point in time. That's for all advocates. Ms. Love and her colleagues, I've told them the same thing. But I think that, my job as the referee is to give you a fair trial. And that's what I'm going to do.
Well, I hope that's true. But you just told the jury I'm unprepared. And I am prepared. I don't understand why you would say that.
Both of you, and I'll level this against the state. Both of you, that's being unprepared, because that I have to then listen to this to rule on it.
I understand, but I'm the only one that the jurors here, the court, take ire with. Ever. Without an apology, without.
Oh, I think I've taken Ms. Love and Ms. Hilton and her colleagues to task many times.
No, I've heard you yell.
I've taken them to task as well.
I've heard you say to her, stop interrupting me. Answer my question.
That's taking them to task.
The jurors never heard that. Ever. So I asked for a continuing recusal motion. And I know it's not in writing, but I assume that you're ruling on it right now. That's what you're saying.
Well, when you got to put it in writing, but I mean, I'll rule on it at this point in time. I'm going to deny the motion, but you need to put it in writing if that's what you wish to do. And I'll appropriately.
I'm also asking for a mistrial based upon your statements. I think I made that clear, but I'm asking for a mistrial.
Okay, now, Ms. Love.
I don't think it's a fair forum for Mr. Williams.
Okay.
And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it.
Y'all, real quick, be aware of this. For the defense to be granted a mistrial, they have to show that the prosecution, or that they were goaded into it. Basically, the defense, to get the mistrial, they have to basically show that they didn't want to, but they were forced to. That's why Steele just said, I don't want to, but I'm forced to, I'm required to. Like I have to, based on what you said. So you're going to hear that a lot from the defense with these mistrial motions, where they're reluctantly asking for a mistrial.
in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
All right, Mr. Steele, in terms of what I've told you all already, we're still going through the, I've told you all, both sides have told you. So this just delays the trial. I mean, where I've got to rule upon other things.
Well, I made this motion whenever I made it, and I raised it, and you said we'll get to it.
Yeah, but it's timing. I mean, did you raise it when we first got in here this afternoon? Did you raise it yesterday? Did you raise it kind of so I could kind of take it at that point in time? None of you did.
If I would have been told that there were going to be 3 additional jail calls, I could have raised it. The 2 others are already in. I didn't object.
All right. Okay. All right. Ms. Love?
Your Honor, just the state would ask that the court deny the motion for mistrial. The state has provided to the defense these jail calls. We have actually requested more than once what portions are objectionable, what portions do they not want us to play. We have sent them to the defense in a format that they can listen to them offline without having to have the actual CD in. We have had them converted for them. The objection that we got initially was put to the call that Mr. Steele essentially put in by playing the recording of the interview that Detective Quinn did with Adrian Bean. And the whole jail recording that was played during that interview was State's Exhibit 175, Charlie Alpha. So the portion that they initially said that they objected to, that third party portion, and we had a motion on it, they actually introduced by playing the call, the interview with Detective Quinn. I have said to them, I'm certain that Ms. Hilton has communicated with them via email that we are using the jail calls. And I know I personally have asked, what do you object to? So at this point, I'm not certain why there is this motion. I object to the language that is used, I'll die if the court does this. Your Honor, the court is well aware of the times that the state has received reprimand, both in front of and out of the presence of the jury. I'm not certain where that's coming from. I would ask that the court, of course, the court has already ruled, but the notion that there is a bias, I'm not certain even where that's coming from, given the amount of tongue lashings we've received from the court on the state side. So I would just object to the defendant being granted a mistrial. And I state for the record that the portion that they identified for us that they objected to regarding the jail calls was entered through their cross-examination of the witness, Adrian Bean. Thank you.
What about the sealed document Mr. Steele is raised or made an issue of at this point?
With relation to the sealed document, that was a memorandum of the interaction that a lieutenant with the district attorney's office had with a party as it relates to Mr. Steele's interaction with that party, unsolicited, after walking out from the stand. That party made comments to members of the district attorney's office. The state asked that party, and we did not assume facts that were not in evidence. We asked, unlike the question, why did you do this? Or why did you do that? Which would assume facts that were not in evidence. We asked the open-ended question with a good faith basis for doing so, and with an ability to impeach if there was a denial of having said it. So we didn't make that up out of whole cloth. We wanted to make certain that all parties on the defense side had that random. And frankly, Your Honor, I think it is improper for anyone, for certainly any member of the bar, to stand up during the cross-examination, direct examination, and offer testimony essentially to a jury. So for Mr. Steele to stand up in the middle of my redirect of Adrian Bean and to say that did not occur, or preposterous or outlandish, is completely improper, disrespectful. The state has done nothing of the sort. And we would ask that Mr. Steele be reprimanded for doing so, and the court rightly did so. And to have him ask for an apology after he has been blatantly improperly acting before the jury, I don't know what else I could say. I would just ask that the court admonish counsel for testifying during trial. I have given the court the basis for the questions that I've asked, and I've never asked a question that assumes facts that are not in evidence. Unlike the question, why did you know that? Do you recall that? I didn't phrase my questions like that because I know not to do that, and I'm not gonna do that. And I don't want to improperly give the jury an impression of something that exists or that will be shown that I can't show them. So there is a real clear distinction in what Mr. Steele asked, implying, why did you give a statement at the hospital? And he keeps conflating what it is that is objectionable. He keeps asserting something so that everybody in the ethos is asking, oh, where is this interview? Where's this recording? He's never seen one. He doesn't have a good faith basis for asking for one. And yet he continues to put that question out there so that everyone in the universe has this idea, oh, the state is hiding something. Oh, the state destroyed evidence. Again, they sat there for a whole day asking witnesses about the destruction of evidence. There was no evidence that anybody destroyed any evidence, yet they stood there a whole day and asked someone about that. And then he asks a witness on the stand under the guise of impeaching him, do you recall that? Or didn't this happen? Or can you explain why the state would delete, or can you explain why the state failed to record your interview at the hospital? And he has no information that an interview at the hospital exists. So all of that, Your Honor, I don't know if Mr. Steele wants, to give an impression. I don't know. He's vigorously advocating for his client. That's what he is supposed to do. But I would ask that the court deny all of his motions. They are baseless. And I would ask, I've taken my licks from the court. We all have. And I'd ask that the court deny the motion for recusal. The court has made rulings that obviously the state hasn't agreed with. The court has made rulings that other people haven't agreed with. So this notion that somehow the court is biased, when as recently as a few days ago, I caught it hardest. It was played everywhere. I'd ask that the court just deny Mr. Steele's motions, all of them, out of hand.
All right. Ms. Hilton, do you have any explanation as to why this third call was just disclosed today? Is that true? Is Mr. Steele correct?
No, he is not, Your Honor. These calls have been turned over. As a matter of fact, I'm getting ready to send an email to defense counsel that shows when they asked us to have the calls converted because they could not hear it on a CD, they asked us to have these calls converted. Literally on January 5th, and I'm actually in the process of forwarding these calls. Mr. Smith sent these calls on January 5th, all of them. I believe a few weeks ago, this is the email that I'm looking for, when this case was first going to happen, probably in December, when we were to disclose to defense counsel what media we were going to use. I believe in one of those emails, and that is what I am looking for, I told defense counsel, we're going to use all of the jail recordings. So this is not a surprise to them that we're using the jail calls. The only call that has ever been objected to is the first call that was played yesterday. They have not made an objection to any call. Now, they just want to know which of the 8 calls this is, then the state has no problem to do that. But to say that they just received the calls or they just learned about the calls, that is not true. They've known about the calls. Now, for me to identify this last call, I can do that. And I'm going to look for the email, or it might have been conversation in court. But when they asked, what media will we use? I think I said, we're going to use all the jail calls. And we're not actually using all the jail calls. We're going to use 5 of them. So this is not new evidence for defense counsel.
Sir.
About and maybe this will give a path moving forward that's a little bit more efficient, hopefully. There are thousands of jail calls in this case. So,
Your Honor,
hold on.
Not for this case, for Acts 5 to 7 specifically.
Okay, there are thousands of jail calls for this case. So they gave about 10, 12, however many jail calls. They're saying, I'm not going to dispute that. I don't have my computer in front of me. But it seems very inefficient to me that we're going to litigate, and you want us, the defense, to raise our objections to thousands or even 12 jail calls and suggest redactions for all these jail calls.
But when did you get the jail calls? When did they tell you? Didn't they tell you like within a week or two, like I asked before, that they were going to use these calls?
So, Your Honor, they just identified one as the chicken call. That's not how they are in discovery. So there's a cross-reference number. So we need to know exactly what call by the cross-reference number in discovery. There's nothing labeled chicken call. There's nothing.
All right, but listen, is there a certain number of calls for this particular act or acts? Yes or no?
I can't, I don't have the email in front of me. So
yes. Okay. So there's how many? 8, 10 calls? How many?
Your Honor, there's actually 8 calls and 2 of them were duplicates. And so in the email that I broke down to them.
So in preparation, you know that if this particular act, which we've been dealing with for weeks, you only got about 12 calls to listen to, right?
So yes. So you would like us to proactively state our objections for every call and litigate, because they're not using every call.
Only if it becomes an issue, because if you all work it out, that's fine. I don't have any issue with that. But if it's going to be an issue, then I need to be able to vet it. I got to listen to the call. I got to listen to the evidentiary basis as to why it should be admitted or not admitted. That just gives me time to do that. And if you say it's only going to take about 15 minutes or whatever, well, it may take longer than that. You see how long we've been out dealing with this issue. So that's what I mean by forewarned judge is a happy judge. So if we could take it up and I don't have to either have them sit in their headquarters, it's better for all of you.
I do not dispute anything you're saying, Your Honor. All I'm doing is suggesting that if last night or yesterday we were told tomorrow we plan on playing this call and it wasn't the chicken call or the whatever call, it was whatever the number is in the discovery or on the email, then we would certainly, I would say it would be on us. But that's not exactly what happened. I just want you on, and I'm not trying to, I really like Ms. Hilton a lot, so I'm not even trying to argue with her or say she's done anything wrong. It's just, I think if we know a little bit in advance, and it's not just, the chicken call, then we would be in a better position to lodge our objections to you. Because right now they are, I assume they're getting the cross-reference numbers, so then I can bring those numbers to the defense table so we can pull up the exact calls that they want us to review. So that's kind of, I just wanted Your Honor to understand it's not as simple as just we didn't listen to the chicken call.
Your Honor, if I may respond briefly, Mr. Williams, I believe, filed a motion in limine number 40. That was the only motion in limine that we had as it related to a jail call. And that was objecting to the third party information contained in jail call number 175, Charlie Alpha, again, that Mr. Steele introduced by playing the interview of that Detective Quinn conducted with Adrian B. So we have again turned over the 8. We can specifically give track 1, 2, 3, 4, 5 of CD 1, 2, or 3. We can give that information to them. The way that Ms. Hilton and Atkins noted and time hacked each of these calls references specific information in the call. That is the only reason Ms. Hilton identified it as such. But there were 8 calls. There is no other call within which the information she has spoken to the court and described the call using. There's no other call that has that information out of the only 8. So I'm not certain the reason for the reference to thousands of jail calls in this particular context. But, Your Honor, we have 8 jail calls here. We've turned over. We've asked, what do you object to? And the only thing that we've gotten was motion in limine number 40 from Defendant Williams.
All right. Anything else before we recess? I still got to allow you to listen to the phone calls.
Okay. The facts got lost. The accurate facts. I've listened to all the calls, the relevant calls. I've listened to them all. I know what the chicken call is. I know what the baseball call is. The issue is there's third parties making statements of fact, introducing statement of fact. We argued this. The state's position was it's non-hearsay because it goes to the effect of Mr. Bean, who will be a witness. I dispute that. I believe it's hearsay. That was the issue. Yes. You said, we'll take it up.
Yeah.
That's it. I'm not saying I don't understand the parameters. The only call that had an issue is Madam President, District Attorney Hilton said, I don't remember what the third call is. I'll let you know on a break. I was comfortable with that. But I just want you, before these jail calls are being played, to make a ruling, because I waive it.
I
on
need
whether
to hear,
it's
I need to
hearsay or
hear the
not.
call though.
Exactly.
Okay.
That's
all right.
what, that was my objection. That was it. And I did it in a manner that I thought was appropriate to say that we raised it. Your Honorable Court told me to let you know. And then we got here.
All right. All right, N105? Yes, sir. Okay, all right, they're both denied. I'll note your objection and the continuing objection, Mr. Harvey. All right, we're gonna take, did you have something, sir? Okay, we're gonna take 15 minutes so you can listen to the call, and we'll come back at that point in time, okay? Now.
All right, y'all, this is going to be so that was, I didn't see that Glanville actually ruled on the mistrial motion. So maybe he did later on. I don't know. So this is going to be the last one. So that was 3 mistrial motions. This is going to be the last mistrial motion, I believe, for today. So let's go ahead and do it.
Good afternoon, sir.
Good afternoon, sir.
And good afternoon to everyone again. Mr. Ryan, I'm glad you're okay. I haven't said anything of substance. Your Honor.
Sure.
This is the first I heard about it, so I just want to inquire if we could have a minute with the state. There may be some impeachment information that we're entitled to under Brady with the prongs of impeachment as well as exculpatory. And and I know nothing about it, but if the witness is not going to say anything, I'd like to know that before the jury comes out. Or if she's going to invoke some amendment, privilege, I'd like to know that too, because it should not happen in front of a jury. Now, I have no basis. I'm just learning about this, but that's what I would like to find out.
Okay.
She failed to appear. She was picked up on a material witness warrant. That is why she is in custody. So
Okay.
there's no, all of that going. There are no outstanding charges. She did not appear. She was subpoenaed. She did not show. We had to find her.
I understand, but if there were any communications, I'd like to know. If there were any communications at all, like why didn't she appear? What was said? I mean, if you have that, we're entitled to it.
No. You can certainly, for the benefit of all counsel, indicate any conversations that you may have had with a witness prior, which caused you to, that would be, I guess, responsive to Mr. Steele's inquiry.
Okay. Your Honor, the witness has indicated from the beginning that she did not want to testify. When I met with her late last year with Chief Investigator Randolph with our office, we spoke, and she emphatically indicated she did not want to be involved. We told her that we had to, this is what we have to do. She indicated that Mr. Anderson, who is her child's father, was the way that she said initially, she started off with, I blocked everything out from then. I blocked everything out. And I said, okay, let me just start off with the fact that I'm sorry that all of this has happened to you. And then she said, I've been in a bad place. I went to prison. I learned my mother was sick, terminally ill while I was in prison. The year after I was released from prison, my mother died the day after my birthday. And there have been times when I didn't want to go on, but I had these 3 boys, so I have to go on. We talked about herself, her family. She indicated that when I spoke with her and said, let me just say, I asked her whether anyone ever contacted her following the 2013 robbery by the defendant Williams and Mr. Murphy. She said no one had ever spoken with her, that we were the first ones that spoke with her about that. She said, I said to her, well, I suppose, and I was remembering differently than what the report read. I said, I suppose that's because the officer said that they called you and apologized and gave you your stuff back. She said, what officer said that? When did they give me my stuff back? I said, this is what I think I remember from the report. We had it seemed amicable kind of interaction. She agreed to meet with us again as time went on, if we needed to, when we needed to. Later, as it grew closer to the time that she needed to appear in court, she came here for court. Earlier this year, I went outside to talk with her again. I had reached out to her by various means between that time and the time I first met with her. When I sat down to talk with her, she said, I want to take my life, essentially. And I asked her, what had happened, why? She said, you're making me feel that way. So I left. I walked away from her and called in an advocate, and our lieutenants, our investigators were called. They then called an ambulance. She indicated that she did not need an ambulance. After needing her the next time, most recently, we were trying to reach her to appear on March the 26th. We reached out to her several times. She did not appear on March the 26th. One of our lieutenants reached out and said, we don't want to have to get a material witness warrant for you, but you have to answer our calls. We then came to, we secured a material witness warrant. In the meantime, after that had been secured, she texted our office and said that she was in the hospital, but we had eyes on her home. Her car didn't leave the driveway. So officers went into her home, went to her home and executed a material witness warrant for her arrest on yesterday. She was taken into custody yesterday. She was not happy. And as a result of that, Your Honor, I also wanted to bring to the court's attention, as far as what she will say when she comes in here, there is no privilege to be invoked. So I know she does not want to be in jail. She has made, I'll call them savory comments as to what can be done to her. She's not a fan of our office, and that's where we are. Additionally, Your Honor, as a result of all of those facts, I wanted to just point out, I don't know if she's going to be cooperative. I don't know if she's going to be hostile, but I've printed out for the court's consideration and copies for counsel of questions. I may have to ask her questions that are closed-ended. They will be maybe one-word answers or closed-ended questions. Those have tended to garner objections, but I just have case law that says a question that requires a yes or no answer is not a leading question. A leading question is a question not suggesting the desired answer, is not leading, where it inquires only into a single fact. That's Milner, M-I-L-N-E-R versus the state, 258 Georgia App 425. Wiggins versus the state, 338 Georgia App 273 is a 2016 case. The Wiggins is 338 Georgia App 273, which states a question is not open to the objection that it is leading when it does not suggest the answer desired. So the court found that questions such as, now, would she actually hold your hand during this time? And now, did he ever get his private part inside your vagina? That they did not suggest the answer desired. That the questions, in fact, did inquire into only a single fact, but because they did not suggest the answer desired, the questions were not leading. The court also cited cases wherein the question, was any money demanded of you, was argued as leading by an appellant. The court said that was not a leading question. And allowing a prosecutor to ask a 14-year-old witness, did you see the defendant with a gun, was also not a leading question. And as to that issue, the last case that the state has for the court's consideration is Burden. That's B-U-R-D-E-N versus the state, 332 Georgia App at 811. That's a 2015 case, which also says a question is not open to the objection that it is leading when it does not suggest the answer, but only inquires into a single fact. They cited Milner for that assertion on the court's part. So, Your Honor, I do anticipate asking closed-ended questions as opposed to more open-ended questions. But unless the witness proves herself hostile, we won't need to lead. If, however, she does prove herself hostile, the state is prepared to ask the court for permission to treat her as such. And we have the cases for that as well. And I would point the court's attention to ISA, spelled I-S-S-A, versus the state.
When was that decided?
2017.
There's some more recent case. Todd Brown versus the state, 314 Georgia 193.
We have that as well.
Okay.
Thank you.
All right.
So we are not at this point asking that she be treated as
We
a
need to see
hostile.
what she says. And
Right.
What comes up.
What's the second?
Issa, Your Honor, is,
That was Mr. Matthews.
I know, I was just addressing the
Okay,
court, but
that's
for
all
his benefit. That was 340 Georgia App 327 at Penn Site 340.
All right, thank you, madam.
You're welcome, Your Honor.
Yes, Mr. Steele. I'm sorry, Mr. Harvey.
Let me just comment for the record that we had a 1 o'clock start today. None of it was provided to us this morning or yesterday. So, I mean, it's pretty disingenuous to come in and start, hey, I'm speaking, to start citing cases and saying I can ask these questions after the state arrested somebody yesterday and holds them in jail, number one. Number two, everything that I heard that was stated to the state is Brady material. The person's mental state, what she said, the statement that was given, none of which we were given that I know of. So in number three, I do object to the public not being able to see this witness under the authorities that we have already provided to the court and argued previously. So number one, I don't think this witness should be shielded from the public. We have been provided with nothing to verify that she is in any particular danger that would overcome the Sixth Amendment openness provision of this particular trial. Number two, I would like that Brady material and a chance to digest that with my co-counsel prior to this witness testifying. So I object on all of those bases.
Your Honor, if I may respond briefly to the assertion by Mr. Harvey that not showing her face
on camera is a violation of their Sixth Amendment rights. This court has made these proceedings open to the public. The court streams these proceedings via Zoom down to another courtroom in this courthouse for anyone who chooses to see it. Anyone who desires to do so can come inside the courtroom by permission of the court, if the court allows, and can go into that other room. What the defendants do not have is the right to dictate where media, who is filming for the rest of the world, places its camera. The camera has been focused on defendants at various times, solely focused on defendants at various times during these proceedings. They have absolutely no right to dictate where the camera is pointed, and certainly not to tell this court what to allow or not to allow to be filmed in this courtroom. Also, Your Honor, on February the 6th, 2024, Mr. Uhelsky provided to this honorable court and co-counsel as well as the media proposed orders on the state's limitation for recording, and indicated in that email that entry of the proposed order would not implicate, let alone infringe, any defendant's Sixth Amendment right. No constitutional provision guarantees a right to televise trials. The public trial guarantee of the Sixth Amendment, which reflects a concept fundamental to the administration of justice in this country, certainly does not require that television even be admitted into the courtroom. A public trial implies only that the court must be open to those who wish to come, sit in the available seats, conduct themselves with decorum, and observe the trial process. It does not give anyone a concomitant right to photograph, record, broadcast, or otherwise transmit the trial proceedings to those members of the public not present. That is Estes versus Texas, 381 US 532 at Pennsite 588 through 589. So, Your Honor, one, as it relates to an asserted Sixth Amendment right to have any witness have their face broadcast all over the world, there is no such right. And number two, I disagree wholeheartedly with Mr. Harvey. We have provided this witness's name, information. Mr. Harvey has not made any indication whether he sought to speak with her. These statements that she made to me are very much more inculpatory rather than exculpatory. Brady is exculpatory. She never once even suggested that the defendants on trial, specifically Jeffrey Williams, did not come to her house with Walter Murphy and his brother, while the defendant Williams' brother put a gun to her head. She said that I asked her whether or not the defendant Williams and her child's father, before this point in time, whether they were actually friends, whether they had been hanging out. She said yes, but she said, you know, she did not want to be involved in this. She is just like every other witness. There is no recording that we have received from this witness that we are obligated to turn over. The fact that we are having her brought out in handcuffs that I'm announcing to the court after her arrest yesterday, as well as counsel for the defendants, that this is the case, and just goes against, flies in the face of the assertion that there's something being withheld from the defendants.
All right. Anything else, Mr. Harvey, before I allow some of your other colleagues to?
Yes, I think the court has been provided with a number of authorities that defendants have the Sixth Amendment right to an open in public trial. That's not even debatable at this particular point in our jurisdiction.
Our cameras are in the courtroom at this point in time. The question is safety of the witness and the like.
Nothing, not a thing.
Well, I disagree with Mr. Harvey, so I'm going to overrule your objection. Do you have anything else, sir?
All right, well, for the record, I have not heard one factual basis, not a scintilla of evidence or a proffer that this person has been threatened or is in danger of in any way that would overcome Mr. Nichols and all these gentlemen's Sixth Amendment rights.
Okay, sir.
One.
Thank you. Anything else?
Two, impeachment evidence is Brady. Someone who says, I don't remember something now, that's impeachment. A person who.
Did you seek to interview the witness? You had the witness's availability for almost 3 months. So you could have gone and interviewed the witness and gotten this particular evidence yourself.
That has nothing to do with whether the state has an obligation, a constitutional obligation to provide everybody with exculpatory impeachment or giglio material under the United States Constitution, under the Constitution of the state of Georgia. And the fact that they interviewed them, this person, and that material is useful for impeachment, that is and falls under Brady. And so we're entitled to it. And we're entitled to it before the 1 o'clock when the witness is about to get on the stand in a jail uniform, which is the fault of the state, not us.
No, I don't think so, Mr. Harvey. That had the witness decided to just honor the subpoena, then a material witness warrant wouldn't be necessary. So that's a choice of the witness.
Your Honor.
Let her finish and then we'll go ahead.
Your Honor, additionally, when she was taken into custody, as I told the court, the witness, when I spoke to her, told us that I made her want to end herself. She accused us of harassing her, of harassing her. So there's that.
And just briefly.
Yes, absolutely.
I just want to point out to the court the order entered by this court related to the videoing of witnesses. The order that was entered by the court.
She's going to be videoed. She just won't be shown. They just asked that their face not be shown.
The order that Mr. Uhelski prepared and the court signed says that the witness or state may request that only audio of their testimony be recorded. In addition, for any specific alleged victims for whom there are legitimate security concerns that can be substantiated by the victim or the state, the victim or state may request limited identifying of the witness. So I'm not sure that there have been legitimate security concerns substantiated by the state.
Miss
Your Honor, I will point out
Ms. Love.
that this witness is now in custody at the Fulton County Jail. We have endured weeks of testimony from a witness whose face was shown, who provided outbursts during court as a result of what happened when it was made public that he was coming in to testify, even when he chose to recall nothing. So we are, based on what has happened in this trial so far, in the interest of justice and in the interest of judicial economy, we are asking that for the sake of this witness, her well-being, her feelings of safety, that we not show her face.
In Your Honor, I still do not hear legitimate security concerns that are particular to this witness.
Okay. All right. Thank you, Mr. Weinstein. Yes, Mr.
I would ask the court to require the state to proffer in specifics in terms of this particular witness.
I think that already this based on what Ms. Love said already and the court's viewing of what has gone on with the last several witnesses that have had their faces broadcast to the world, that there's a legitimate safety concern. So I'm going to overrule your objection. It's noted for the record.
And for the record, Your Honor, on that same note, the prior witness that came into court stated that his information had been broadcast. I didn't specifically.
He lost his job. He has been harassed. That's a security concern. Do you want you may want your phone number handed out because it's business to you, but for some people, he lost the job.
Losing your job is not a security concern, Your Honor. That's an employment concern.
Well,
Respectfully.
I disagree, given everything that this witness told us on the last witness who testified. The court will disagree with your analysis.
And I think that's a slippery slope, Your Honor, because now any witness, based upon the last witness, can come into court and state.
No, that's not true, Mr. Matthews. It's based upon what the witness endures on the stand and the collateral consequences to that. So I'm going to disagree with you respectfully. All right, Mr. Sharp.
Yes, Your Honor. So I agree with Mr. Harvey that Brady includes not only exculpatory material, but also impeachment. But in the state's recitation of what occurred in their communications with Ms. Bennett, I heard several exculpatory statements or things that I deem exculpatory, that she has not been harassed or threatened by any individuals here, that she told the state that her significant other continued to associate with Mr. Jeffrey Williams after she made these accusations. That she is.
I don't think that was said by the state or by the witness.
She accused the state of harassing her.
Yeah, okay, that was.
And so these are exculpatory statements. These are impeachment. They fall under Brady. And Your Honor, I would ask, and I have something else after this, but I would ask that the state, I noticed Ms. Love said we don't have any recordings that we are obligated to hand over, which qualified her statement about recordings. I would ask that any recordings, any communications, any emails, any written statements by detectives, any notes that involve these episodes with Ms. Bennett and oral statements be reduced to writing that have anything to do with Ms. Bennett, because we are obligated to impeachment and exculpatory information. Additionally, Your Honor, I would ask that Your Honor, instead of calling the jury out to have the initial determination of where Ms. Bennett is and if she's a hostile witness or not, that we have a hearing outside the presence of the jury. I would ask that Ms. Bennett be provided legal counsel, because it appears that she may be under some legal jeopardy. She may have given false statements back then, and she's being brought in to testify now. And I would ask that she be provided legal counsel. She be allowed to communicate with legal counsel. And then we have a hearing outside of the presence of the jury to make some determinations before the jury hears from Ms. Bennett. Because I think there's a high chance of we're walking on thin ice with unknowns here. Of course, we're finding out about this for the first time.
Did you interview her as well? Did you seek to interview her?
I seek to everyone.
Did you seek to interview her, Mr. Sharp? Yes or no?
Your Honor, I know.
Did you seek to interview her? Yes, you personally, on behalf of your client.
Me personally, I have not.
Okay.
She has been interviewed.
All right.
So.
Okay. Anything else?
I don't do everything involved with my cases. There's investigators, there's other attorneys.
Okay. Did you have an investigator go and seek to find her?
No, I did not.
Okay. All right. Have a seat. Anything else? Anything else?
How many
No,
times
that's
has
it.
Grand
Okay,
Jury
all
said
right.
have a seat to Sharp during these videos we've watched? At least 5. At least 4, maybe 5.
Thank you, Your Honor. I just would like you to consider this as well. So when I researched, I heard the former witness, Mr. Bean, his answer was consistently, I don't recall, something that I don't remember, I don't recall.
Among other things.
That's pretty much, my memory was, I don't remember.
Okay. Among other, yeah, I would concur that was a lot of what he said.
So I researched that to determine whether this is I understand hearsay. If a person doesn't recall, then you lay a foundation and you get in the prior inconsistent statement because, whatever they said or prior statement. But under confrontation clause, it seemed to me there's not all that much on it that I could find, but that the federal courts and Georgia, one case in Georgia, has said that I don't recall the person's not shutting down, so that satisfies the confrontation clause, but constitutional. So statutory is protected because I don't recall lots of cases say you can impeach with the prior statement to lay the foundation, and then the confrontation clause under the Georgia Constitution and the federal Constitution may, I don't want to concede it, but that's why I didn't object. The reason I bring this up to the Honorable Court, I have no idea what this next witness may or may not say, but if she truly shuts down, I just want you to know that that's why I don't want it to happen in front of a jury. I will be asking that nothing be said. You know, the prosecution cannot ask leading questions, leading or non-leading questions, because if the answer is I'm not answering, then it's a confrontation clause violation. That's why I want to bring it to your court. But when I heard this, that you know, it progressed, but she's in custody. I knew something happened. That's why I asked Brady. We heard that then, and then depending upon what she says, I just want to alert you, Your Honor, that there may be a confrontation clause violation, which of course, you know, you asked us to tell you, which is has to be harmless beyond a reasonable doubt. So it's the highest standard except for structural error. So I'm just letting you know, I have no idea what she's going to say, but it might be best practice to just ask her outside the presence of the jury, what's your intention? And if she says, I'm not here, I'm not talking with anybody, it's a dangerous thing to put in front of the jury. I'm just doing what you told me to do. So I'm making that confrontation clause argument now. I know it's not right because I have no clue. She might testify. But if she doesn't, I'm just letting you know that, you know, I'm going to be asking to approach and move for mistrial and strike.
Your Honor, I would ask Mr. Steele too, if there is case law that even suggests what he is saying, that he provide us with the cites, because my reading of the law is entirely contrary to the notion that he is proposing to the court, that what happened with Adrian Bean implicates confrontation rights. So I would also ask the court to inquire of Mr. Steele if he has any recordings of this next witness, if he had an opportunity to interview her, and what she told her, what this witness told Mr. Steele or any representative for Mr. Steele, since he is asking the court, because I don't know what strategy there is. I don't know if it has ever been, and I'm not suggesting that he did it. I don't know if someone told her, just don't say anything. I don't know, but I certainly would ask that the court not bring her in here outside the presence of the jury and ask her these questions and provide her an avenue. She has already indicated that she does not want to be here. For us to have to get a material witness warrant
She's a
for her.
reluctant witness. Does she have any type of criminal charges or anything that would?
She does not have her case happened in 2011, and she was sentenced as a first offender in 2014, I believe. And then that was in another jurisdiction. And then that was revoked when she got charges in Fulton. And all of that information has been turned over upon an open records request by Mr. Steele. So she was under sentence she was sentenced here in Fulton after she was revoked on the Clayton County charge. She is out of prison for that. And there are no pending charges against her. There's nothing, she doesn't have charges. Also, Your Honor, according to Allison, Allison versus the state 356 Georgia Act 256 at 258 through 261, the Court of Appeals has said in 2020 that a witness's inability or unwillingness to recall specifics in their testimony does not make them unavailable as a witness for purposes of hearsay and confrontation clause objections.
You're not conceding that.
You, yeah, I
You're not
said
conceding
that
that. You said that,
correctly.
yeah.
I said Mr. Bean testified. I don't recall. I said that's why I didn't object. I found one case in Georgia that said it's not confrontation clause. I told you it's definitely not hearsay. I mean, yeah, there's nothing to, there's nothing to rebut. So anyway, I don't know. I shouldn't get frustrated.
No. I mean, do you have any other case law that would say it's the confrontation clause issue? Because Mr. Steele, it looks like right now we're possibly faced with a witness that's reluctant. Would be probably the best term.
The way I understand it is it depends on how she acts.
Exactly.
So if she's, and I have no clue, if she sits up there, what's your name? I'm silent. Is your name this? Silent. That would be, in my opinion, a violation of the confrontation clause because there's no opportunity to cross. Different than, I don't recall, but that's a statutory right. And as I told you, in Georgia, there's a confrontation clause case that says it's not a confrontation clause. So, you know, it just depends on what she says.
But
That's why
she's here.
I'm
I mean,
trying to-
and I could, depending upon what she does say or not say, allow her to be treated as hostile so that leading questions could be asked. She'll answer them. She may not answer any of them.
Right.
I mean, and then you still have the right to examine her. I mean, but she may not say anything. I mean, that's the other thing that may happen.
And that's my issue that I brought to the court. If truly nothing is spoken, then I have a violation of the confrontation clause on behalf of Mr. Williams, Mr. Matthews Jr., et al. Have that. I'm just trying to raise it to the court.
Your Honor, in the interest of justice, I would ask the court to inquire of Mr. Steele if he has any information, any recordings of this witness, anything of that nature that give him reason, or even if he doesn't give him reason, if he has any recordings, if he has any information, if he had the opportunity to
Did you interview the witness, Mr. Steele? Did you have the opportunity to do that at some point in time? Because that does factor into whether or not part of my analysis as to whether or not there's any other information.
Your Honor, I don't have to answer that question, but I don't mind answering ex parte on a sealed record, and the defense can come, but not the public and not the prosecution. So if we could go into your chambers, or everyone not with the prosecution, not with the defense, be excluded, and not with the court staff, not staff, the court's chambers, then I don't mind sharing with the court.
I'm not asking for anything that's privileged. I'm asking for an inquiry into whether or not he had the opportunity to interview her and whether or not he made any recordings. I'm not asking for the content of those recordings, if he wants to call it work product or whatever. But I'm asking, in the interest of fairness, they are making assertions, assumptions, and all sorts of requests of the court. I'd ask that the court simply inquire, one, whether Mr. Steele interviewed her, interacted with her in any way, and two, if he has any recordings. Whether or not the state is privy to those is an entirely different other matter that I'm not even reaching right now.
Your Honor, I'm not, I'll do exactly what I said, and your honorable court can listen, hear, view, read, whatever you want, but I'm not doing it in front of the state. I don't have to do that. And it's the same thing that Ms. Love did earlier. I don't have to do this, but I don't mind. There's no wrongdoing here.
And Your Honor, if they're not willing to do that, then we're just ready to talk.
But we can't make these assertions and not do it with the court.
Because we'd rather not delay the process.
All right, folks, please, let's not do that. Let's not get into any of that. All right, give me a second, please. All right, it's clear we don't know what she's going to say. However, that's just the whether or not she testifies as to what, will be within her decision to do so and to testify truthfully. My concern, or the court's concern at this point in time, is that you, being the defense counsels in this case, may not have had the opportunity to talk with her about what she is going to say. I don't know whether or not my concern, as well as based upon the state's proffer of what they have said to her, is it may or may not be impeachment, it may or may not be Brady, but I think in order for you all to satisfy yourselves, you should be given the opportunity to talk with her. So I'll let you do that over the next 30 minutes. So you can talk with her and see what she says, and then we can kind of take it from there. Those who are interested in doing so. So that's the court's suggestion. So I'm going to be in recess.
Your Honor, I want to make sure she's sufficiently separated from the defendants. I know that she's going to come out over there, but I would ask.
I'll let Sergeant Ingram and his colleagues facilitate that issue. Okay? Won't worry about that. I'll let him and his team resolve that. Okay? Then based upon what she tells you or doesn't tell you, I'll fashion or consider other things. But
And Your Honor, given that she does not have to speak with anyone, Your Honor.
But I'm going to give her the opportunity based upon what you proffered. I don't know. I really don't know whether or not anything that you have said to her would be exculpatory or would be impeachment. But I'm going to let them decide whether or not they want to inquire about that, because impeachment can be Brady. So, but I don't know. We don't have a good handle on what she's going to say. So I'm going to give them the opportunity to at least go ahead and do that. They've had the opportunity over the last 3 months. They've known who the witnesses. They certainly, I believe that one counsel has probably interviewed her. And that might be Mr. Steele. The rest of them, I don't know whether or not they've done anything in that respect, but they have, and that's certainly something that they and their clients are going to have to take up. So based upon what you said, and just to make sure that there are not any, that they're authorized to determine whether or not, or anything that was said is of Brady or maybe of Brady, then I'll go ahead and do that this time.
Yes, Your Honor.
So.
All right, y'all. So that was the video. This was a long video, so I cut it there. We have a Brady cliffhanger there. So I want to thank all of y'all for joining in, watching. Thanks to my mods, Miss Lily. I saw that you said you're suffering or you're undergoing some health challenges, and same to my mod, Andre. So everybody, if you pray for my mods, please. If not, send them well wishes. Thanks for joining us. Nick, thanks for joining us. Kat, thanks for joining us. All the new members, all of the people who gifted memberships, who became members, who sent super chats. I want to thank everybody. If you haven't hit the like, please go ahead and hit it. If you haven't subscribed, please subscribe to us. And I'm up. Oh, so I'm going to do another one tomorrow. Again, I included this last one because it was a Brady issue. We'll see if it turns into anything or not. Also, if there's time, we'll probably deal with some of the written motions as well. So we'll see. We have 5 more days, no court. So I plan on working on one of these per day. All right. So I thank everybody. Pretty good stream today. Nice crowd. I think Kat sent some people here. Kat, I don't know if you did or if you didn't, but thanks for gracing us with your presence. All right, y'all. I'm out. Have a good day. Have a good Thursday. Is today Thursday? Yeah, have a good Thursday and see y'all back mañana. Bye-bye.